All right. Well, thank you, Will, and thank you to the other panelists as well. I'm very appreciative of the opportunity to be able to discuss IP considerations in a post COVID-19 world and considerations. And I have a PowerPoint presentation that will hopefully get put up here. And here it is. So in this, I'm going to be discussing intellectual property considerations in a COVID-19 pandemic world. What have we done? What are some countries doing, and so forth. So let's hit real quick on the roadmap. First, we're going to discuss the world's response, or part of the world's response to this pandemic through the lens of a little bit of background in the intellectual property realm and how things are going. Then we're going to view compulsory licensing and IP waivers. And then we're going to discuss the Medtronic ventilator license and go a little bit deep into what Medtronic did last late spring 2020 or mid spring 2020 once the pandemic started to hit. So let's start off with the world's response. Back in 1994, when the WTO, the World Trade Organization, was put together, there was also an agreement on trade-related aspects of intellectual property rights, otherwise known as the TRIPS Agreement, which sought to harmonize legal standards across WTO member states. So as a member state wanted to become part of the WTO, one of the conditions was that they had to accept the TRIPS Agreement. And on the next slide, we're going to talk about one particular article, Article 31. This has been in the news lately, and it's been in the news because Article 31 recognizes compulsory licenses. A compulsory license removes an obligation of a WTO member to recognize exclusive patent rights before a patent has expired. In other words, governments can order a domestic manufacturer to make the patented product without permission from the patent holder. Now, one of the things that I will state here is that um, there is a clause that, so if you're reading Article 31, you're going to go in, you're going to take a look at it, and one of the first conditions is that you negotiate with the patent holder. If that doesn't occur or you don't obtain an agreement, that's where this potentially this compulsory license can kick in. The second condition is listed there in the case of a national emergency or other circumstances of extreme urgency. We're not going to so much focus in on the public non-commercial use because right now, of course, in COVID-19, it's national emergency, and of course, it was deemed a world or a pandemic late last year. And so this potentially kicked in, and we've had some discussions, or there's been some WTO members that have discussed this, of either trying to obtain a compulsory license or initiate this, and or obtaining an IP waiver. And on the next slide, what we're going to see here is that IP waivers differ with respect to the compulsory license. Basically, what a country would be doing, or a member state would request that countries be exempt from certain provisions. So in October of 2020, this came up when India and South Africa petitioned the WTO for a temporary waiver until widespread vaccination occurs. The best way to think about a waiver is you're putting those intellectual property rights on hold. And with regards to that, we're just setting the stage here because one of the things, and it might be on the next slide here, um, the things to be thinking about, sometimes it might be a little bit of a red herring to think of it from the intellectual property rights. The reason that I state that is because you're going to have potentially supply chain issues, especially within the context of the vaccines that are rolling out now. Typically, vaccines were introduced by parts of a virus, or they were manufactured from parts of a virus or a weakened virus. However, the Pfizer and the Moderna vaccines are not traditional vaccines in that they use messenger RNA or mRNA to cause host cells to produce those spike proteins that we see so much on the infographics nowadays. So, with this, there's IP issues, and those IP issues that are presented with novel vaccines, well, technical information may be lacking. These companies may be more reliant upon trade secrets in light of recent Supreme Court cases related to patentable subject matter, and they could present some supply chain issues in addition to potential IP issues. And I'm going to dig a little bit more into what I mean by that. So, why would this technical information be lacking? Well, companies, these compulsory licenses, while they affect patent holders potentially, they don't necessarily get attributed to trade secrets. For those that aren't aware, patents are a grant or are basically a monopoly right granted by the government. In exchange for that limited monopoly right, the patent holder or the inventors must disclose to the public how this invention or this new technology was developed and how to reproduce it without undue experimentation. Trade secrets, on the other hand, are on the other end of the spectrum. They can be maintained by basically any economic benefits that's derived. It could be something like a customer list or how you optimize the production of this mRNA. So the two things here is potentially lack of technical information is number one. And number two, you might not have all of those raw materials since there could be a shortage. So that in and of itself can be unrelated to the IP issues at hand. So it's just important to recognize when we're seeing some of these articles out there saying, hey, we should give up the IP rights and so forth. That is worthy of a discussion. But the other side of it is, do we actually have all the raw materials, the supply chain, and everything else? So let's move to the next slide here. And we're going to discuss in this one the open source ventilator. This is an example of what one major company did when the outbreak happened. In early 2020, Medtronic made available some design specifications, manuals, design documents, software code for a relatively low cost portable ventilator. So basically, they opened the treasure chest to this specific portable ventilator. But as we're going to see here, I'm going to cover briefly just some of the IP provisions that Medtronic utilized. And what you're going to see is characteristics of a copyleft license. Now, what's a copyleft license? Well, a lot of this copyleft comes up within the confines of open source source code. So it's granting the right to freely distribute and modify the IP, but there is the requirement that those same rights be preserved downstream. So, and the public policy behind this is that anyone can benefit freely from previous work, but whatever they develop and whatever modifications they work on should benefit everyone else and must be released under the similar terms. And so here's just a brief example to kind of clarify where things are. We're going to have, and I want to hit on each of these different pieces, but to provide the copyleft license, we have a source code. It might be a device driver source code or whatever. Think of a computer developer uh, going online, finds the right source code that makes their design work. They decide to modify it and however they need to do it. And so once it's available or once they make that modification, under the terms of a copyleft license, if they're going to distribute the product and so forth, they're going to have to make those changes and their modifications open to the similar to the agreements as what they obtained their code, their source code under the copyleft license. So I grabbed a few permissive license terms. This is what it was called, a permissive license, allowing others to develop these portable ventilators. The first thing is, of course, the enclosed materials. I wanted to show what each of the things were subject to and what they were delivering, Medtronic. Two of the important clauses here that I wanted to hit on was, of course, Medtronic trademarks, that the person or the entity that is developing utilizing this open source technology is not authorized to use Medtronic names or any affiliates of Medtronic. And that makes sense because Medtronic doesn't have any ability to control the type of portable ventilator that's coming off. They've provided the designs and so forth, but they don't want their goodwill necessarily hurt or harmed as a result of something going wrong in one of these portable ventilators. And so there's a trademark restriction. The other thing, and this was the copyleft restriction for modification, and here's the clause here that talks about if you modify, transform, or prove, or build upon any of this, you must make those modifications available under the license that includes the terms identical to the terms of this license. So, as you can see here, it's restricting any intellectual property rights that might be further developed by an entity that engages in this portable ventilator design. So you could imagine that the entity is designing a widget that improves something within the ventilator, the operation of the ventilator. Under that, those modifications would be required to be available under the license and terms similar to the license that they've engaged in. So I want to again thank Will for this. And if you have any questions, there's my contact information. I truly appreciate it. And thank you very much.